It started. Hi guys, it's Kathy. It's not supposed to start like that. It's supposed to ask me when I want to start my live stream when I press that button. But it just started my live stream, and that's fine. But I don't have this link in Discord. So if you're in here, which no one is yet, give me a second to put this link in Discord. I don't know why it does that. I'm working on this new software. There we go. It's frustrating. It's frustrating. That's fine. And I can't edit the first part out of my streams because YouTube is funny like that. Oh, I lost my chat bit window. Now I can't see if you guys are chatting. Happy Saturday, guys. Sort of do need to see if you're chatting though. There we are. Happy Saturday, guys. Oh. All right. So yesterday we stopped. Hi, Bill. Yesterday we stopped with the prosecution questioning the mousy woman mother. And remember, he grabbed her foot, he twisted it, and she heard a pop. That's what you should remember about yesterday, not the other thing. Definitely not the other thing. Can you just forget about the other thing? And then today, and they rested yesterday. So I don't know how she's going to do today because the defense gets up. I mean, I don't even know what we're doing. It wasn't the prosecution yesterday? No, it was her lawyer, wasn't it? Asking her what happened. And now the prosecution's going to get up and destroy her, which there's a lot of video watching today. Unfortunately for us, we don't get to see any of the videos. So she was just sort of sitting there in court watching these videos for 10, 20 minutes at a pop with no sounds. We don't get to hear it. We don't get to see it. So I just cut those portions out so it'll look like you'll notice it. You'll notice when they say, okay, do this, and then all of a sudden it's 30 minutes later. But that's because the only thing that happened during those 30 minutes is some coughing by some of the people. So here we go. I'm going to press play. Hopefully this works. Yeah. Oh, no. Hold on. Now I can't hear it. There we
You
go.
can go ahead and sit down. And I remind you, ma'am, that you remain under oath, okay?
Yes, sir.
All right. Direct examination had concluded, and now Ms. Dickerson, cross.
Thank you. Okay, I wanted to go back and talk a little bit about some of the things you said on direct examination. Being a content creator, that's your primary job right now. And I'm so sorry, I tell everybody this. You're gonna have to answer yes or no, because we're recorded.
Yes.
A huge part of your online platform is actually connecting with other people who have survived domestic violence.
Object. 403, 404.
Response?
I could actually back up and lay a foundational question first.
Go ahead.
One of the videos that you have on one of your social media platforms, which is TikTok, depicts you in front of Dr. Mulcan's office talking about this allegation of domestic violence. Is that a yes or no? I'm sorry.
Yes.
Thank you. And you've made other videos and connected with other content creators who talk about this exact topic.
No.
When you say that this is your new job, this means that this is how you support yourself.
This has been my job for 4 years.
So it is how you support yourself.
Yes, along with teaching.
So you also testified on direct examination that Kiefer obtained the restraining order by saying that you physically hurt him.
I believe so.
And you were served with a copy of this protection order.
Yes.
One moment. And just to clarify, on the date that you were served with a copy of this protection order, it was the date that you were ordered to vacate the home that you shared with Mr. Byer and Miss Mary Jane Byer.
I didn't share that home with them.
You were ordered, when you received this copy of the protection order, to vacate the apartment that you were currently staying at where you had been letting them stay.
I was told to leave my home.
I got a question, real quick, off topic. Okay, I know Terry Ham knows what this is. I think at least 50 to 60% of the rest of you know what this is. But do you guys know what that is? It's a hotly debated topic. Do you know? No one knows what that? Of course, you guys know what that is. I know you don't all have them, but you should maybe know what they are. No? Okay. Whoopie pie. Whoopie pie. Whoopie pie. Now it's a hotly debated topic whether whoopie pie is a Pennsylvania thing or a Maine thing. Maine actually made these whoopie pies their dessert. Their state dessert. National. Maine made a national dessert. It's like 2 pieces of chocolate cake almost. And then Maine uses marshmallow inside. And we use icing. Like a Cool Whip icing. You know what I'm talking about? And they're just it's a whoopie pie. It's a whoopie pie. So it's a purely Pennsylvania Dutch food. So I don't know why people think it doesn't come from Pennsylvania. But in the summer we have tons of freaking vegetable stands, fruits and vegetable stands. We have tons of Amish. We have a lot of Amish. So whoopie pies are freaking everywhere, especially this late in the summer. You can get whoopie pies everywhere. So remember I said that my son, I cooked dinner the other night? A couple nights ago? 3 nights ago? 2 nights ago? My son brought me a whoopie pie. I don't know what is going on with him, but he brought me home a whoopie pie last night. Yeah, Kelly, it is really sweet. So I was just not in the mood for 3 tons of sugar last night. But I bet you sometime around hour 3.5 of streaming, me and that whoopie pie are gonna have some fun. All right, back to work. If you don't know what to make a whoopie pie, they're really easy. Get a recipe and make a whoopie pie.
Ms. Crowell, if I could refer you to what's in front of you. This is the restraining order that restrained you from being near Mr. Kiefer Buyer or Miss Mary Jane Buyer. If I could refer you to the second to last
Right,
page.
first off, I need foundation, not a statement. You ask a question.
This
And then, ma'am, I know it's hard, but we do need yeses and nos, not mm-hms and mm-ms.
Yeah, I'm so sorry.
Ask a question, please.
This is the restraining order that you were served with that resulted in you needing to leave your home October 7th. Is that yes or no?
I'm still trying to get to the page you told me to get to.
Oh, no, it's okay. Just that is
Oh.
the same restraining order.
I believe so.
It lists you as the restrained party and Kiefer Buyer and Mary Jane Buyer as the protected parties.
Yeah, they're both protected.
And you were served this on October 7th, 2024.
I don't know the exact date, but I was served it, yeah.
If you refer to the second to last.
She's not asking questions. She's making statements for the lady to just agree with, and that's annoying.
Page. Nothing on that page alleges that Kiefer Buyer said that you hurt him physically.
Not a question.
Is that correct?
That's a question.
I believe it's in his written statement.
But what is on there is that you threatened violence towards Miss Mary Jane Buyer, a child in the home.
It says
Object
that.
to hearsay.
Sustained.
I'm so sorry.
May I respond?
No. It's hearsay. Sustained.
But just to recap, nothing in that alleges that Kiefer said that you tried to hurt him.
Object hearsay.
It's already been answered once.
I'm reading.
I just wanted to clarify.
Oh. I mean, it doesn't.
1 second.
And you know, I'm going to sustain the objection.
Okay. I'm going to approach and grab that from you.
Okay.
Jury will disregard that entire colloquy.
Judge, I would object.
Approach, please.
I want to go back to the keys. You said on direct examination that Mr. Buyer stole your keys. Can you answer with a yes or no?
Yes.
And you said on direct that you initially had given him a key to the home.
For emergencies.
But later you took that key back secretly.
Yeah.
You also said on direct that you had a spare key the entire time.
Not with me.
But you had a spare key.
I had a spare key, yeah.
So actually you took his key back without him knowing?
Wasn't his key. I had asked for it back and he refused to give it to me.
Okay. But you testified on direct examination that you initially had given him a key.
For emergencies.
And the entire time you had a spare.
Terry, I knew
Right.
you would know.
You also
During the incident, because he had taken that key, my spare key was hidden.
when you testified on direct examination, you talked about an incident where Mr. Buyer asked you to show him your vagina.
Yeah.
In order to ensure that you had not been having sex with anybody.
Mm-hmm.
I want to go through everybody that you talked to before you made this statement. So you talked to 2 sets of officers who showed up the early morning hours of October 7th.
Mm-hmm.
And you
Need yeses or nos, please.
Yes.
I'm sorry, I didn't even catch it. And you never told this to the first set of cops who responded to your house.
I was scared.
Please answer the
did not.
question. Yeah.
No.
Okay. And you did not tell this to the second set of officers who had responded to your home and asked you what had happened.
I didn't.
You also went in for an interview at the Rosandom Center and you talked to Detective Olazaba.
Mm-hmm.
And this was the opportunity where you talked about for the first time how violent everything had gotten.
Yeah.
And you did not mention in that interview with them that Mr. Byer had ever asked you to show him your vagina to prove you were not sleeping with anybody else.
How would I prove it? It's hearsay.
The question was, you did not say this to the detectives on October 8th.
I didn't. I was scared.
I also want to talk about infidelity. You conducted an interview with the district attorney's office December 12th. They came to your apartment. Do you remember that?
Yes.
And at that time, you said that you had believed back in October of 2024 that Mr. Byer had been cheating on you.
Yeah.
I want to go back to the argument that was touched on regarding Mary Jane Byer. On October 7th, I guess this would technically be October 6th, before your family had gone to sleep, Mary Jane Byer went to Walmart without your permission.
Went to Walmart. I don't know where she went.
She left the house without your permission.
I don't recall if she left that day or not. It might have been the day before, because I know we had an altercation about it on the 25th or the 28th of September as well.
You talked about how you and Mr. Byer had an argument or a disagreement about his daughter leaving the home.
Yeah, absolutely.
Without permission.
At 11:30 at night in fish nets and thigh highs on West Colfax.
So you just testified that Miss Mary Jean Byer left the home at 11:30 at night without your permission the night before?
She tried. I wouldn't let her go.
Okay.
There was an incident where she did get
What? And I'm sorry, I haven't asked the follow-up question yet. I just wanted to confirm your testimony. You recall that on October 8th, you spoke with Detective Olazaba, and you gave him a statement about what the fight was about.
It's not muted. It's fine. Relax.
I'm going to approach and ask you to wear some Bluetooth headphones, and then I'm going to go ahead and play a statement and ask you some questions about it. And that statement that you gave to Detective Olazaba, you said that Mary Jean had left the house at 8 o'clock at night, not 11:30.
She had tried.
Okay.
So I should have worded it better.
But that it was 8 o'clock, not 11:30.
I mean, again, like, these are times that I'm supposed to have written down. It was at night.
What I'm specifically asking about is that in the prior interview with Detective Olazaba, you said she left at 8 o'clock.
It truly depends on which moment we're talking about.
Is that what you heard in your statement to Detective Olazaba? Just
I
now?
heard that she had tried to leave the house at 8.
Okay, thank you.
But there have been other times that she had to
I just wanted to stop you right there. I don't want to ask about other times. You wanted Mr. Byer to punish Mary Jane Byer for leaving at 8 o'clock at night or trying to leave at 8 o'clock at night.
Right. And it was actually more than just that. She had been.
And I'm so sorry. I'm just asking you the questions. I don't want you to give any additional background information. I just want to make sure we're staying within the confines.
Not everything is just yes and no, though. There's context to it.
I just want to make sure that we stay within the rules of evidence. Okay.
Okay.
So Mr. Byer had gotten home that morning, around 3:30.
Could have been. It was anywhere between 2 and 4 that I recall.
Stop.
Okay.
I don't know the exact time.
I can't watch this trial.
If you don't know the exact time, would it refresh your recollection to refer to a statement where you gave a more exact time? This would be your statement to Officer Fink on the 7th.
Right. I mean, the officers would know better than I did because I called them shortly after.
Would it refresh your recollection to see what you said to the officers?
Yes.
I'm
Okay.
going to object because, well, she already answered the statement of when it was between 2 and 4.
Overruled.
Approach again. In that statement
Yes,
that you gave
and we
to
won't
Officer
finish.
Fink, that was the same morning,
Yeah.
just later that morning.
Mhm.
And in that statement, you said that he came home at 3:30.
Right.
Okay. Mr. Byer came home and it was your belief that he was drunk.
He told me he was drunk. So yes,
And he initiated the argument.
initiated a lot of things. Yes,
He initiated the argument.
absolutely.
He would not let you sleep.
Nope.
He was essentially emotionally abusing you.
And more.
Bobby, is that better? Or is it different?
Miss Crowell, are you aware that around 3:30 in the morning, when this argument was going on, that you were being recorded?
Absolutely. He loved recording me after he would hurt me.
And this would have taken place in yours and Mr. Byers' bedroom at the time.
Yeah, that was probably when I pushed the phone out of my face.
Specifically, do you recall during this argument that you called him names?
Probably.
You called him a dick ass.
Yeah.
And you said, fuck you.
Yep.
And all the while during this time, Mr. Byer is not saying anything in response except good night.
Because he was pretending to be asleep
Okay.
after hurting me.
You also stated, I wish you weren't in my fucking bed.
Yeah.
Get out.
Yes.
Are you going to talk to her tomorrow or not?
Object.
What does that mean to who?
To Mary Jane.
Overruled.
I don't remember exact words. I was fighting for my life, so.
Would it refresh your recollection to listen to that?
Sure, if you would like to.
Well, actually, at this time, I would be moving to admit this under the basis that we previously talked about, outside the presence of the jury.
There's been no foundation for the admission of anything at this point.
In that same video, he beats me up.
Hold on a second. Hold on a
Listen to that
second.
part too.
Hold on a second.
I believe the foundation for impeachment has just been laid.
I disagree. And impeachment is qualitatively different than admission.
Given what Ms. Crowell just testified to, I would ask to show her the entirety of the 12-minute video, and I would ask to be able to do that outside the presence of the jury.
Can you show her what you need to show her? Prosecution have a copy of this at this point?
No, they allowed me to review ahead of time, but I don't have a copy.
Linus, you first.
So, Ms. Crowell, you said, I heard you vaguely say, I remember. This is...
So let's ask follow-up. You just asked her to listen to something. Let's ask follow-up foundational questions, please.
This is the argument from the early morning hours of October 7th.
That's part of it, not the beginning part at all.
And you had testified right before you actually got to listen to the video that this argument would have taken place before, or excuse me, after he physically hurt you.
The argument was the whole time, for days.
This particular argument took place after he had already physically hurt you.
No, this was, well, he had come home and made me undress and do everything.
One moment. This argument occurred then before
This was
he physically hurt you by taking you to the ground, twisting your foot.
This was like literally right before.
Okay. I want to talk to you about that because in the video, we do not hear Mr. Byer escalating along with you.
Because he was recording and he knew.
We do not hear.
We don't get to hear the videos because she played it with the headset on. So all we saw was 20 to 30 minutes of her sitting there going,
him yell at you.
Not at that moment, no.
We don't even really hear him respond to you except to say, "Good night, Constance."
He was pretending to be asleep after having me strip my clothes and emotionally abusing me, as well as other ways.
And if you could stick with the question, he says, "I have to get up for work in 3 hours. Please, Constance."
Objection, hearsay.
Folks, there are times that the court will allow something in not for the truth of the matter asserted. Sometimes the court lets in something for a limited purpose. And this is going to be one of those situations. So I'm going to allow this question not because there's any truth to what that statement purports, but what's important is the effect it may have on this listener. So that is the reason I'm going to allow this question and answer. Go ahead.
What was the question? I don't remember.
In the recording, you hear Mr. Byers say, "I have to be at work in 3 hours, Constance, please."
Yes.
In this recording, you are the one who is yelling at Mr. Byers.
I wanted him to leave.
And he's not leaving. He's asleep in bed.
He's faking to be asleep in bed.
And you're saying that this demeanor that he was exhibiting of being soft-spoken, of not engaging, is the demeanor he was having directly before he committed a heinous, violent act against you.
It was, see, that's where the question is complicated, right?
I'm saying this
Counsel, you do not interrupt the witness when she's answering. Go ahead.
So he was horrible to me, and then he got real quiet, and then he was horrible to me again. He knew he was taking that video. Of course he's going to change how he's acting.
That is changed how he's acting from essentially whispering and being sleepy and going for minutes without even responding to you.
Yes.
At this time, we would be moving to admit Exhibit E from defense side in order to show the demeanor.
May I have word, dear?
Counsel, approach.
I'm going to ask you a little bit more generally about the video. So you said that you recognize this as the portion of the argument that you and Mr. Byer were having about whether he would talk to MJ.
Yeah.
And to your knowledge, is that portion and what you can hear from your voice and Mr. Byer's voice an accurate depiction of that portion of the argument? Let me ask you this way. You recognize your voice as the female voice.
Yeah.
You recognize Mr. Byer's responses as the male voice.
It's him talking.
Okay.
But he is not talking like how he normally does.
And for the portion of this conversation, this is for the portion of the conversation that we're talking about. I understand that you said that there was some stuff that happened before and some stuff that happened after. This is an accurate portion of that argument.
This is 12 minutes out of an entire morning.
Based
I
on
got to
that,
see
Judge,
that
I would
side
move
of
to
it.
admit.
All right. Any voir dire?
Yes, please.
And I'm sorry, has this been marked for identification?
As E.
Echo?
Echo.
Thank you.
So, Ms. Crowell, is this the first time you're listening to this recording?
Was this the one I just listened to?
Correct.
Yeah.
And understanding this is just for a period of time in that whole incident, did this recording capture everything from the start to the finish?
Absolutely not. Just the smallest sliver of the entire situation.
But within the situation when he started recording or when the recording ends, did that capture that full interaction between you and him?
No.
Are there
Rest of the video is where he shoves the camera in my face and I push it out and then he beats me up.
parts missing from this recording that you remember?
You can
Tona,
even hear the
thank you,
pause in the
thank you, thank
video
you.
where he's taken something out of it. It's around 10, maybe 9 minutes where the audio cuts off and then it restarts. And then the end cuts off too.
So when there's silence on the recording, are there times when no one is speaking?
There are times where no one's speaking and I'm just speaking and I'm trying to get him out. I'm trying to be, I'll be honest, I was being horrible.
Are there times when you think someone should be speaking, but you can't hear anything on the recording?
Yeah. He asked me if I'm okay through text message and then he geared at it to anger me. And then I noticed my money was missing. And that's when I get upset at the end.
Okay. And so is this recording a fair and accurate representation of that portion of your interaction with him that night?
Can you question or
Yes. Is this recording you listened to, is that an accurate clip?
no, not with everything taken out of it.
Your Honor, I object to authenticity as well as under 403, 613, and 801.
I take that back. I think we do get to hear some videos soon.
Anything further?
Yes, as a response or as follow-up to Ms. Crowell?
You're the lawyer.
Do you have any questions based on the voir dire?
Ms. Crowell, when I was playing this 12 and some odd seconds recording for you, were you nodding along and saying yes while you were listening to it?
Mostly the parts where I want him to get out.
Okay.
And I'm pleading for him to leave.
You listened to this 12 minutes and odd second recording from start to finish. And
I cut that
the
out for you.
argument that you and Mr. Byer
Professional.
are having, or more that you are having with Mr. Byer, is logically flowing. There is no point in which you hear the audio completely cut out.
You hear it completely cut out. You can hear it. It's in the video.
And Judge, I would ask to publish an order for her to point this out. I think this is a determination for the jury.
I disagree. Whether or not you can lay a foundation as to whether this is what you purport it to be and whether it is accurate or altered is your burden as a proponent of the evidence. The testimony thus far is that what has been played to her is not accurate, that it has been manipulated in some way. I'm not going to allow it in.
I want to ask you some follow-up questions, understanding that we are not admitting this exhibit, but based off of the testimony before you were able to hear it. You could
This
just give me
lawyer's
1
driving
minute.
me crazy.
You testified before you were able to hear the video that the video captured Mr. Byer beating you up.
Yeah, it would be at the very end where it wasn't. He didn't have time to turn off a video attacking me after I pushed the camera out of my face.
What you heard in this 12-minute video was not Mr. Byer violently attacking you?
Because he snipped it out.
And in fact, what you hear of the parts of Mr. Byer that you hear throughout the entire video, you hear him very sleepily responding, "Good night."
He was drunk. He wasn't sleepy.
Judge, I would ask to play this for the jury to allow them to make a decision about whether or not that is true. Otherwise, I cannot impeach.
Counsel, you're asking questions based on opinion. You have your answers.
If I could have one moment.
He can't hold your hand. He can't tell you what to do, ma'am.
May we approach briefly? All right. One moment. So I'm going to switch gears just a little bit. And I want to talk about the sequence of events that you laid out on direct examination regarding the alleged assault. I know we've talked about this a bit, but you did not lay out any of the details about Mr. Byer twisting your foot until it popped for the officers who responded on October 7th.
Like to my house?
Mm-hmm.
I don't know. I don't remember.
Would it refresh your recollection to hear what you told them?
I mean, sure. Which group of officers?
This would be
The second or first?
the first set.
I didn't feel comfortable with them.
Okay, you said you don't remember what you told them. Would it refresh your memory to listen to their officer body worn camera?
You can show it to me if you'd like, but I'm gonna tell you right now, they were not on my side and they weren't happy to be there. And you can very obviously see that they just didn't want to do the paperwork. That's why they let him stay. I wasn't gonna get
Specifically, what you said today was that a violent assault took place.
Yes, and it did.
What you said to the officers was that you can't remember, something happened, and it made you feel unsafe, so you locked Mr. Byer and his daughter on the balcony. You did not tell them that he tackled you with his full body weight and slammed your head against the ground.
They wanted to spend more time talking to him. I did not feel safe talking to them.
When officers were speaking with you, Mr. Byer and MJ Byer were downstairs, not even in the apartment when you were speaking with the police.
Yeah, because they left to talk to the police first.
And so you were not in the same room as Mr. Byer when you were giving them your statement?
I was not. Mr. Byer wasn't in the area, I don't think.
You were free to give them the exact true rendition of what exactly went down that night.
It was not free because I knew that they weren't going to help me. They had already said, they had started it by saying, I don't want to get anyone in trouble here. You can hear it.
When you spoke with the officers that day, you said you don't want to get anybody in trouble.
Right? Would you want to get the person you loved in trouble?
Objection, non-responsive.
Sustained. Look, ma'am,
I'm sorry.
don't apologize. I understand it's hard being a witness, but counsel is going to ask you questions. Do what you can to please answer the question that she asked.
Yes, sir.
So you specified that you did not feel comfortable with the first set of police.
Yeah.
There was a second set of police dispatched within about an hour after the first had left.
Mm-hmm.
And could you say yes or no?
Yes.
You did not take that opportunity to tell those officers that there had been a violent assault whereby you were tackled to the ground with Mr. Byers' full body weight, that he slammed your head repeatedly on the ground.
I don't quite remember, but I do know that they know I was hurt because I did show them my head and they had to help me with my bag to my car.
Would it refresh? And I'm sorry.
Sorry. I was talking about when they came to get me out of my apartment. Can you, I'm sorry.
So you said that when we were talking about the second set of officers, you don't remember necessarily what you told them. Would it refresh your recollection to hear yourself giving that statement?
I mean, yeah.
Okay, give me one moment.
Do I have to watch the whole video?
It's a small portion. And I'll go back next. Okay. So the purpose was to refresh your recollection so I could ask you some questions about the second set of officers. You did not tell the second set of officers that Mr. Byer had sat on the floor or kneeled on the floor and twisted your foot until it popped.
You can actually hear in the video that I wanted it investigated and that the first set of cops did nothing. It says it when it highlights injuries, it literally says I wanted them to investigate, but they wouldn't. And that's also leading to the reason. There's also evidence on there saying that he was threatening me and I was being blackmailed. So that's
At this point, I am going to object to non-responsive. I would move to strike. On the video that you just watched, there was nothing about you asking the officers, the second set of officers, to investigate your twisted or broken foot.
No, I was going to take myself to the hospital.
Okay. So if you were going to take yourself to the hospital, then at this point you were not asking them to investigate any further injuries.
I had my children with me.
Okay. Okay.
I couldn't leave in an ambulance when I have 3 sleeping kids.
Do you recall, so what you just testified to is that you had your children with you. Do you recall having a recent trial preparation interview with the district attorney's office this month?
This month?
In August of this year.
I'm sorry, what?
August 12th. Do you recall attending a trial preparation meeting with the district attorney's office? With your daughter, Lilith?
That was when is that when I went to the city?
The district attorney's office is downtown, so did you have a trial preparation meeting in the city recently?
It wasn't a child prep meeting.
Sorry, trial.
Oh, a trial prep meeting? Yeah.
Okay. And in that meeting, you told the prosecution that at the time you were just trying to get your kids out.
I was trying to keep them safe.
But what you
Whether
specifically
that's out or in.
What you specifically told the district attorney's office is that you wanted to get your children out of the apartment.
Yeah, when he wasn't leaving.
Okay.
Keep in mind, like I've got more than just my 3 kids. I've got pets.
You also have a car that's parked in the apartment complex, or at the time in October 2024, you did.
Yeah.
At no time did you ask either set of officers to escort you.
Both of these women have me so annoyed right now. Both of these women are just bad.
To your car with your children so that you could get them to safety.
Because that's all I had. And that apartment was everything I own.
Okay.
Of course, I don't want to leave willingly. It's my home. It's my safe space.
You testified earlier that you gave Mr. Byer a key for emergencies and that he did not live with you.
Yeah, well, he's looking for a place. So yeah, he lived with me, he was staying with me, but I didn't formally say like, you're moving your whole entire life in, you're here to stay forever, especially after things started falling through. That's where, even in that video I mentioned.
I don't mean to interrupt. I just want to make sure that we stay within the confines of what we're talking about. Officer, the second set of officers that you were talking to, specifically the one in the video where you just refreshed your recollection, was the one who let you know that Mr. Byer had established residency by living with you for so long.
Legally, but not legally. He knew the laws of, he knows squatters' rights, and he utilized that.
And you were specifically told by the first set of officers that this is not squatters' rights that we're talking about.
I don't remember saying that at all.
Would it refresh your recollection to hear that statement?
Yes, I would like to see that.
Just one moment.
Don't pause
okay.
it because I explained myself.
Hold on.
Take your time, lawyer. The judge needs ponder breaks in between.
Watching something. No questions. So please just, when you're watching something, you just need to watch it. Then there'll be questions.
So the question was, you were told by the first officer who responded to the apartment that morning that this was not squatters' rights.
Because he didn't know about the messages where I say he needed to leave 2 months before.
Objection, non-responsive.
He said it wasn't squatters' rights.
Overruled.
What we heard in that video was the officer saying, no, it is not squatters' rights. He has established residency because you let him live here.
That is what he said, but he did not know that he was already in the process of being out.
Regardless, the police were not able to force him to leave.
I'm confused by what you're trying to.
Legally, there was no mechanism. He had established residency.
He said that he established residency. They believed him.
But you were the one who told the officers in that very clip that he had lived there for 6 months.
I said he had been staying with me for like 6 months, but he wasn't actively living with me right then. And I even say it that he wasn't actively living with me, that he had already moved out and been staying with Josh. So it was squatters' rights. Respectfully.
So the most recent video that I just showed you, you recognize yourself in that video.
Absolutely.
And you recognize that you are speaking to the officers about when Mr. Byer moved in. And it's your testimony today that you did not tell the officers that he had been there since you moved in.
I did. I said that he had been staying with me since I moved in.
What you said is, I got this apartment and he moved in like immediately after.
He had needed a place to put his stuff when he wasn't staying wherever he was staying.
So the testimony was that you told officers that he was in the process of moving out. But what I want to make clear is that you also told the officers he moved in like immediately after you. That was 6 months ago.
Right, he needed a place to stay, to
Okay.
find a place to stay. As a girlfriend, I offered my home for him and his daughter.
I want to talk about when you locked Mr. Byer and his daughter on the balcony.
Mm-hmm.
At that point, it was approximately 4 in the morning on October 7th.
Probably, yeah.
The sun was not out.
Mm-mm.
So it was purportedly cold.
I was keeping myself safe from someone I knew could kill me. What would you do? I feared for my life and my kid's life.
You told officers who responded that you called your father when they were locked on the balcony.
Yeah.
But then you were interviewed by Detective Olazaba the next day when you went to the Roseanne Center.
Yeah.
And you told on that day to the detective that you called your dad rather than 911 because Kiefer was hanging over you.
Yeah, I wasn't allowed to have my phone.
But what you had told the officers prior to talking to Detective Olazaba is that Mr. Byer and his daughter were already locked on the balcony when you called your father.
He is not going to come after me if it's my family.
Objection,
I made
responsive.
Sustained. Please focus on the question that's being asked.
Ask again, please.
What you told the officers when they responded on October 7th is that you called your dad while Mr. Byer and his daughter were locked on the balcony.
I had them call the police. I might have just gotten confused, honestly.
So now it's your testimony that you told them to call I'm sorry, when you say you had them told the police, call the police, are you talking about your parents?
I had my parents call because if he had been able to get to me.
You told the officers on October 7th that you called your dad while Kiefer and his daughter were locked on the balcony.
That sounds correct.
But the next day you told Detective Olazaba that you called your father rather than calling 911 because Kiefer was hanging over you.
The entire night.
But he was locked on the balcony at that time that you called your dad.
It was safe for me to finally call someone and get help. Yeah.
At the time that you called your dad, Mr. Byer could not have been hanging over you because he was locked on the balcony.
Precisely.
With his daughter.
Would you make a phone call to police in front of your abuser?
Objection, non-responsive.
Sustained.
So it would not have been possible for Mr. Byer to be hanging over you when he was locked out of the home.
This is incredible. He was locked out when I called my parents to call the police. It was the safest thing to do.
And what I'm getting at is that it would not have been possible for him to be hanging over you because he was locked out of the house.
Oh, it's absolutely possible because that door is already broken from him slamming it a billion different times. So the entirety of him breaking in and hurting me was all possible. But that was the moment where I felt truly safe enough to make the call.
Objection, non-responsive. Move to strike.
They did respond.
Overruled.
You just testified that the door had been broken a million times. On direct examination, you testified that this was a deadbolt lock.
Yep.
Okay. So
Giving me time.
It would have been very difficult for Mr. Byer to break through a deadbolt lock.
The glass was falling off of the door.
Okay. But regardless, Mr. Byer and his daughter did not break through. They called for emergency services instead.
Mm-hmm.
Can you say yes or no?
Yes.
When the officers responded on October 7th, you told them that you had nowhere to go.
I don't have a good relationship with my family, so I didn't have anywhere to go.
At the time the officers responded, you were actually on the phone with your mother.
Mm.
And you hung up by saying, I love you.
Yeah.
Your parents live in Castle Rock.
Right.
And that morning, when the officers asked if you had anywhere to go, you said, no, you did not.
Yeah, I owe them quite a bit of money, so it's a pretty...
I don't know how far Castle Rock is from Denver. And I'm not going to Google it. Just that's where they both are.
Uncomfortable stay.
You knew that prior to any of this happening, Mr. Byer was thinking about getting a restraining order.
No, he had no reason to. What had I done?
Okay. You remember talking with Officer Fink the morning of October 7th. He was the first officer to respond.
Mhm.
And it's your testimony that you did not know that Mr. Byer, prior to October 7th, that Mr. Byer was going to obtain a restraining order.
Objection 403.
Counsel's approach.
So, Ms. Kroll, your testimony just now is that you had no prior knowledge that Mr. Byer was intending to seek a restraining order against you.
That restraining order. It's how you worded it.
But
I-
what you told the officers on October 7th, the morning of October 7th, was that you did know that Mr. Byer was potentially going to put a restraining order on you.
Why did I know?
Objection, non-responsive.
I'm not saying I believe this witness entirely, but I am saying that yes, it's 1,000% possible she wouldn't talk to the police. 1,000%. That checks out. That big red check mark. Yes, that's right. It's 1,000% possible she wouldn't tell her parents. Check. Absolutely not. She wouldn't tell her parents because her parents have probably already told her things like, "Oh, he's not right. He's not good for you. Dump him." And she's like, "You don't know. You don't know him. He loves me. You just don't understand it all." There's no way she would talk to her parents. There's no way she would talk to the police. I mean, some people do. Most don't. Because police can't help. They cannot help. So if you talk to the police, you are just in big trouble. You are just putting yourself in humongous trouble. And if you talk to your parents, it's very humiliating, embarrassing. They were right, you were wrong. It's easier, like if a sibling said, he ain't right for you, and then you go to a sibling, that's one thing. But, Mom, I was wrong, Dad, I was wrong, and you're right. No, you wouldn't. You'd be the last people you would tell ever. So she has, her options are to try to get him to move out or to move out herself. And to move out herself, it takes a long time. It's not like something she could just, okay, there is the shelter. She could take all of her kids and her animals. I don't think they take animals, and go to the shelter. Then what? So her options are to get him to move out or her to move out. And it takes a long time to do that. You have to plan. You have to save money. You really have, and you have to do it without them knowing. And during that time, when you're thinking about moving out, things get better. He gets better. He gets nicer, and everything's happy. So you don't work hard to save money to get out anymore, because he's different now. And all the money that you saved to move out, then you start spending it. Well, you know what? I don't need to get out this week. He's being fine this week, so I can take a little bit of this and buy some groceries with it, and then you're back to zero. You have no money. You have nowhere to go, and then he does it again, and you're like, "Oh damn! Kelly, I wish I would have freaking saved that money." But yeah, she wouldn't go to her mom. She wouldn't tell the police. She wouldn't do any of that. She just wouldn't. But she's also lying, and I don't know what about. Here's what I think, and I don't know, but here's what I think. I think she was loud. I think she was throwing things at him, swearing at him. I think she was not this small, meek person, definitely. I think that she was, a pain in the ass to him. And I think she's trying to hide that part by overcompensating with this lying mousiness. And she doesn't want to answer this lawyer's questions at all, which makes her look more like a liar when she's probably not lying about most of it. She just looks like it. You know what I mean? It's just, I think she's very worried about what other people think of her. I think that is her primary concern. What everybody is thinking about her right now. Instead of just you just say what freaking happens. It's a trial. Just say what happened. It doesn't matter. It's all over now. You're in trial. It doesn't matter. Tell the truth.
Let's not ask questions back. Please try to just answer the question that's being asked.
I did know he loved blackmailing me with it.
You also suspected that Mary Jane Byer, who is Mr. Byer's minor daughter, was going to say that you hit her.
Yes,
You did not hit Mary Jane.
absolutely not.
At the time, October 7th, 2024, you worked with children.
Absolutely.
And an allegation that you had hit a child or even threatened would have potentially threatened your job.
Absolutely. And he knew that.
And Mary Jane was 13 at the time.
Yes.
Okay.
Well, I guess I'm out for childcare jobs because you, my son, let me tell you.
So you did bring up in your testimony just now, hold on one second. All right. I want to talk a little bit about your injury to your foot.
Mhm.
So you testified that you were cleared to bear weight on your foot.
I
I'm
was
sorry.
cleared to bear some weight. I was cleared to take it easy, not go jumping.
Your testimony on direct examination was that your foot had healed.
I probably shouldn't have worded it like that.
Your testimony was exactly, my foot was fully healed. I was out of my boot. And at this point in direct examination, you were talking about October 7th or around that time.
I was on the bone stimulator, but I could walk fine. My hardware wasn't broken
So is
at
it,
that point, and that's documented.
I'm sorry, I did not mean to interrupt. So is it your testimony now that you did not just testify on direct examination that your foot was fully healed and that you were out of your boot?
I'm sorry, word that again.
Was it your testimony on direct examination that your foot was fully healed at this point? You were out of your boot?
I shouldn't have said fully healed, but my hardware was not broken and my foot was not broken at that point. My foot was on a bone stimulator to make sure it wouldn't break.
So I want to talk about the activities that you had partaken in before October 7th of 2024, during a time that, well, let me ask you this. Your foot at the beginning of 2024 was not fully healed.
Right.
Speaking about the timeline of January 2024 to July of 2024, you were still in boot non-weight bearing protocol.
I'm sorry, give me the dates again.
We're talking January 2024.
And again, this lawyer, that's not how it works. That's just not. All right, my niece, car accident, hardware, boots. She is supposed to. She's not supposed to do what, like an Ironman race, But she is supposed to use her foot as she can and use the boot as she can. And she's in this she's in the exact same situation as this lady. The doctors have never once told her don't use that foot. Do not. No, she has to use her foot. The hardware is there so that she can use her foot. That's why the hardware is there, so that she can walk on her foot. And I mean, no, she's not supposed to kickbox, but she can dance. She's allowed to go dance. That's why the hardware is there. The hardware is there so she can walk. If she was like completely non-weight bearing, do not use that foot, they wouldn't have needed to put the hardware in. They would just wait for the bones to heal. So this lawyer acts like she's not supposed to, touch her foot to the ground. God forbid. But then she acts like when it was squeezed, she was still walking on it. Yeah, it's her foot. She walks on her foot. It would take, like, she's a mom. She has 3 kids. This is going on with her. Her foot's broken. I've done all kinds of things with 2 broken hands before. I stood as matron of honor for my best friend's wedding the day after I gave birth to my 2nd child. Like, just because something hurts doesn't mean people can't use it. You know what I mean? I could use my hands even though they were broken. They were my hands. I remember lifting the spaghetti out of this pot, and it hurt so bad, but I still did it. So yeah, but if there's testimony metal on the non-weight bearing, whether there was non-weight bearing or there wasn't non-weight bearing. What I think was that after the surgeries, she had non-weight bearing, but that was only for X amount of weeks and not for the rest of her life. And they are taking that slice of time and they were like, look, you did this.
Through July 2024.
I don't know.
Okay.
I would have to see my records. I'm constantly in and out of the boot so it doesn't break.
So, when you are in and out of the boot, you're typically on light weight bearing protocol.
Yeah, or I have my knee scooter.
And light weight bearing protocol means no heavy weight bearing on your foot through jumping or.
This is not funny at all. This is really not funny, but this is siblings, okay? And they did not live with me because I wouldn't have allowed it. But after her car accident, my niece had one of those knee scooters, like she was just talking about. You put your knee on the scooter and then you can just walk. Well, her brother was an amazing football player. And he was a lineman. He wasn't a wide receiver. He wasn't a quarterback. He was a lineman. And every time he would see her in her scooter, he would tackle her. Every time she tried to get in that scooter, he would come from across the room and running tackle her to the ground. There is no words I can explain the rage this woman felt against her brother. They work together now, but he would tackle her, and oh man, he's so lucky I didn't know about that because they didn't live with me. They didn't speak to me. They're my sister's children, and I was at a time where I didn't speak to any of them, none of them, because I couldn't speak to my sister. So he's so lucky that I didn't know about this, because if I would have found out about this, I would have killed him. But now looking back at it, because she tells these stories about certain times when she was tackled, like, and she would be stuck in a bush or something and she couldn't get up, and they're siblings, freaking brothers and sisters, man.
Dancing or anything like that.
I'm not supposed to. Sometimes it happens by accident.
So you just testified that sometimes it happens by accident. You are a model and dancer through what's called Metal Maidens of Denver.
Yes, and I was not working when my foot was injured.
Okay. But you were on not full weight bearing protocol before July of 2024.
I don't know. I would need my medical records.
If I could just have one moment.
Simple Auto, this is Denver. This is Colorado. This is you. You are her. Are you her? Oh my gosh, you could be her. You could be her, and we would never know. Do you know her? Are you guys besties? Because you both live in Colorado, so you should know each other. I really felt I cut out all the pauses like this. I think I missed this one, and I'm sorry.
And just for the record, I'm going to be approaching Ms. Crowell with her records from Foot Specialist Associates.
That's not Miss Crowell, that's the judge. That's the wrong place. There you go. I like her skirt though.
Where am I reading? 6 of 28, 2024.
All right, we're not having conversations. She will call your attention to whatever she's trying to refresh your recollection with, and then she will ask questions.
Okay.
You mean she'll make statements pretending to be questions? Is that right? See what I did there? Sorry.
Yeah, this is for a different leg entirely.
Yeah. JK, I would just say, yep, I know him. I know him so well.
Mm.
Oh, no, no. Can you commit a crime and get in front of Judge Eric? Please, for us. Please, please, please.
Yeah, this was.
So my question is, the dates that you refreshed your recollection on are all prior to July of 2024.
Oh, yeah.
And at no time were you cleared to full weight bear without a boot.
I was allowed this right here where it says I can't full weight bear is a year before the entire situation. It's 2023.
I apologize. But I apologize. I also misread that was 2023. So what we refreshed your recollection with was June 12th, 2024 and June 28th, 2024.
Where I'm talking about my tibia on a whole different other leg.
The question is, you were not cleared to weight bear on your right leg without a boot during that time.
During that time, but I was allowed out of the boot before he harmed me. I was just on the bone stimulator.
So at the
That's
time
for a
that
visit on my tibia, that's not even for a visit on my foot.
So at the time that you were not cleared to weight bear, you were still dancing for Metal Maidens.
I was cleared to weight bear when I was dancing for the Metal Maidens. I would have never been allowed by my manager not to. I injured my foot because of that performance.
But we're not only talking about dancing here, we're also talking about longboarding.
I haven't been longboarding in quite a long time.
Okay, Judge, I'm gonna ask for a break here. I just need to tee up some videos, and I would like to confer with the prosecution before I do that.
All right. Well, it's time for an afternoon break anyhow. So we will go ahead and take a step down, ma'am. You can remember you are testifying, so no one can talk to you about your testimony, but you're free to step down.
Thank you.
Folks, we'll go ahead and give you guys a little bit of a break, let you recharge your brains a little bit. Remember, as always, do not discuss the case at all amongst yourselves or with anyone else. I'm impressed you got Vandal in 3. I struck out today. All rise. No research. Jury's in recess.
I don't know what he said there. I'm surprised you got Pandal in 3. I struck out today. I didn't understand those words.
She does not.
All right, everyone can be seated. We're not going to be taking breaks for you to be prepared for an examination. If you're going to be impeaching, you need to be ready to impeach.
I understand.
So we're taking our afternoon break now. Let's please make sure that what we're attempting to use actually impeaches as opposed to something that's a year earlier or whatever else, because to be frank, I'm completely confused as to where this is going right now or whether this impeachment or not. So yes, talk to the district attorney, and if we need to have a conversation ahead of time, let's be back here in about 15 minutes.
I told you we get to hear more of this judge today, even though it's a trial. There's more too.
Get our mess first.
Let me organize for just a second. Because I agree, I'm confused as well. Yeah, so.
I think we get to the verdict tomorrow. I think it might, maybe it might carry over a little to Monday. I'm not sure. I don't know the exact, but we're almost there. We're not like a week away.
Do you think you have much more?
Probably 30 minutes more.
We never realized that this door opens right to the outside world. I really felt I cut all of this out. I don't know why it's...
All right, we'll go on the record in.
Here we go.
24 CR 6170, People versus Buyer. Attorneys are present. Mr. Buyer is present. We are outside the presence of the jury. And we're finishing up our afternoon break. Just wanted to, before we broke, counsel indicated she needed to prep some videos and communicate with the prosecution. Is there anything the court needs to be aware of?
No, the rest of the videos besides what's been admitted as Exhibit D are all just dependent on what her answers are.
What are these videos?
Social media videos and sorry, I just want to make sure she's not in here. They do depict weight bearing during times.
Look, that was him. He muted it. See the red? See the red little thing? I didn't mute it. it's coming. He's unmuted in a second, I'm sure. Okay, now it should be unmuted. And she's looking at a video. There we go.
Is this a video from your personal social media account?
Yes, it is.
What is the date on that video?
I think he accidentally muted it at that point. and we missed 30 minutes, 20 minutes. We missed some of the questions. So there's nothing we can do.
It's October 16th.
What's the year?
24.
Would you be able to say that in the mic?
2024.
And is this video depicting you at a concert, specifically the Swaco concert on October 16th, 2024?
That's my job. So yes, I did show up to work and I did go to that concert. In the video, I'm not dancing. I'm standing in the back.
All
You
right,
can
hold on. She's just asking questions.
And as you just stated, the video depicts you standing.
It does not depict me standing. It depicts me holding the camera to my face.
And your testimony was just that you were standing in the back of the
It
concert.
shows me sitting at the bar at a show.
When you are, I guess, videotaping the part of the concert that you are not in, that is at the head level of everybody who is in front of you.
There were a lot of people there, and I did go all the way back to the bar.
Okay.
You can see it in the video.
I would be moving to admit defense H at this time.
People object, relevance 4-3.
Let me see the exhibit, please. I assume I don't need headphones because it doesn't sound like this is an audio issue, it's a video issue.
This time, defense would move to admit and publish.
This is H.
H is in Hector.
You want to lay your foundation as to date?
Yes, I can approach with the video again, or if the prosecution doesn't object, I can just approach with the screenshot. Okay. And you stated that this show, or at least the date of the post, was October 16th. The actual marquee that says Swaco shows that the show was actually October 9th.
I don't know when it was posted. I posted it when my manager told me to post it. But it was after the incident, if that's what you're asking.
The date of the social media post itself is October 16th.
Yeah.
The date of the Swaco show, per the marquee, was October 9th.
I don't ever post where I am the night of. It's dangerous for me.
The objection non-responsive.
Just focus on the question and answer the question.
I'm confused by your question.
The marquee that you can see in the screenshot says Swaco, October 9th.
Yeah, I don't know if that's a fact or not, though, because it's the Gothic and they don't always change their lettering to be reminiscent of the night.
But you did attend the Swaco show at the Gothic.
I did, yes.
And going back to the timeline here, you were allegedly injured on October 7th. You spoke with Detective Olazaba, and just going back, the pain that you said you experienced from that was a 10 out of 10.
Okay.
Oh,
Yes.
just hold on a second. The exhibit you're showing her, has that been marked for identification?
Yes, H.
No, I thought the video was H.
The video is H. That screenshot is just to not have to lug the computer back.
Is that screenshot?
Yes, I can bring my computer.
No, is that from the video?
Yes.
All right, so that is a demonstrative
Yes.
For the record, we're going to mark it as exhibit what?
L. Or L was not admitted, so M.
So M is a demonstrative.
So just going back to
Over the objection of the prosecution, I'm going to admit H,
permission to
which
publish.
is the video. Yes, we may publish. I don't think sound is relevant. Does the video have sound?
It does. It's his.
I'm asking. I'm talking to the attorney.
I don't think it's relevant.
But the exhibit has sound.
Just go ahead and play both.
All right. Well. All right. Am I getting likes, Waco?
No. It's my job. I have to go.
All right, let me know when you're ready.
Ready.
It takes like 12 seconds for the electrons to.
You go missing, you could jump right off a bridge, and the space, no.
Yo, I don't want to be demonetized, so I had to mute it real quick. I had to. All right, I think it's done. I hope those few seconds isn't enough to nail me. I see that the chat that I put on the screen is very, 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 very tiny. I'm working
Going
on
back
it.
to the timeline. You did go to this Waco show October 9th.
Yes.
That would have been 2 days after you allege that Mr. Byer broke your hardware with his bare hands.
Yeah.
That would have been 1 day after you talked to Detective Olazaba.
Right.
And that would have been 5 days prior to you telling Detective Olazaba you could not really walk.
Okay. I was not walking here. I was sitting. You can see that I was sitting and spinning.
That will be for the jury to determine. I'm just asking about the date.
Counsel and the witness, we're not having a conversation back and forth. The video shows what it shows. You've asked your question. And actually, for the record at this point, since a transcript will be made, can we spell the name of the band?
Do you want me to spell it or Ms. Crowell?
For the record, you can do it.
That is capital SUECO.
All right, next question.
I'm going to go ahead and repeat the last question because I did not get